which unfortunately we do not seem to have recognized and for which we're not prepared. And the present, the question that we need to ask therefore is whether what we're doing, whether, well, for whatever intention, good or bad, whether what we're doing is actually just a continuation of this trend, whether it's an Orientalist enterprise, meaning that we have now so imbibed the so-called internationalist perspective, the so-called global village, that we are now actually, well, we bought into it so much that we're actually sacrificing our own national interests, our own national resources for the sake of, some big global operation or being being a member of the global community. So let's start with the history. You remember, of course, Spaniards. But actually, during the Spanish period, oh, by the way, I color-coded this so that it's going to be a little bit more vivid without having to be, without having to explain so much. When you see red, it's not just that you're angry. When you see red, that is the exercise of full, absolute, total sovereignty. Okay? And the less red it is, the more orangey or pinkish it is, the less the sovereignty that is exercised. So, when the Spaniards were here, despite their 400 years, actually even up to 1898, they recognized that they did not have full sovereignty over Mindanao. And that's why that is basically what the boundaries of the Philippines were under Spanish rule. Just limited to the islands. Spaniards recognized only, extended their sovereignty into the sea only to the extent, quote-unquote, recognized by international law, which at the time was around 3 miles, according to them, or according to most members of the international community. And even during the negotiation of the Treaty of Paris, you have there in one instance where the Spaniards, in their continuing attempt to prevent the Americans from taking all of the Philippine archipelago, asserting very clearly, very expressly that Spain did not exercise sovereignty over the island of Mindanao. Okay? And you'll find that in the report. Unfortunately, as you know, the negotiations did not go the way that the Spaniards wanted, so we ended up with, the next slide, the Treaty of Paris, which ceded to the Americans everything within those lines. And even though there were questions, after all, Spain admitted that they did not have sovereignty over Mindanao, and yet it is included in the cession. Despite those questions, after a few decades of American rule, there was really no more objection raised against de facto American rule over even Mindanao. So you could say that actually Mindanao came into the picture or became really part of the Philippines only during the American period. And I think the history majors here would probably love to make something out of that, especially in light of the GRP and the processes. Now, there are of course some problems with this box, as you see. It's not perfect and certain islands were excluded and it was recognized that that was a problem. So, the next slide please. The United States and the colonial power over Malaysia at the time came into an agreement and agreed to that line there at the bottom, that very thin unobtrusive line there, lower left corner of that polygon. This is the US-UK Convention of 1930, which defined a line separating the islands of Sabah, North Borneo, and the Philippines. Okay? And then, the Americans already recognized that there was a problem with the line on top because it excluded the Batanes Islands. When you look at the technical description of Treaty of Paris, really the Batanes Islands is north of the northern boundary. How did that happen? Despite the fact that Batanes was actually a Spanish possession, and there were, as early as the 1600s, there were already Spanish friars who colonized the area. Actually, looking at the record of the negotiations of the Treaty of Paris, it is more or less clear to me that it was a typographical error. Because the first time that that line was proposed, it was in numbers, 21 degrees 30 seconds, so basically. But the second proposal was typewritten, it was in letters, and it was 20 degrees. Okay? So there's a problem there. But even around 1905, 1910, the Bureau of Coast and Geodetic Survey in the United States, which was the one in charge of all the maps here in the Philippines, had already recognized that, and there was actually a memorandum telling them that when they published, telling the printing press and telling the Bureau that when you print the maps, move this line a little bit up to reflect the correct, the original intended number. Nonetheless, during the 1935 Constitution, during the 1935 Constitution, this issue came up again, and you'll find it in the discussions, the deliberations of the 35 Constitution on the national territory. If you want to look through those records, the Corp of Delegates then also discussed that problem and proposed actually to define it that way in the Constitution. But we ended up with a more general statement enumerating the three treaties of that the United States entered into in order to acquire possession and sovereignty over these islands. So, next one. Now, from 1946, meaning after we had acquired independence, the Philippine position has been that this entire area, everything within those lines, is the sovereignty of, under the sovereignty of the Philippines. Notice the difference between this box and the one previously under the American period. Because during the American period, they did not assert sovereignty over the entire box, but they were a bit also ambivalent in the laws and regulations that they passed. Okay? But particularly two cases decided by the Supreme Court back then, and certain rules issued by the Bureau of Customs, opinions issued by the Secretary of Justice of the U.S. indicated that the United States considered their sovereignty to extend only to the land and not to the sea, not at least to the extent of that, not to the full extent of the Treaty Paris lines. So you could say really that it was only around 1946 when we acquired independence that this was clear, that this became clearly the Philippine position. Whether it was effective during the Commonwealth period, maybe there might be a huge discussion over that because under the Commonwealth technically they're still part of the United States. So I can only say that certainly from the time of independence. However, 1950s, then you have these negotiations for the Law of the Sea Convention. And, well, it's a long story, but in the end, the Philippines enacted the law, RA 3046, which is later amended by RA 5446, to establish the so-called Philippine baselines. This is the first appearance of Philippine baselines in Philippine law books. That's what they're supposed to talk about. So we're not actually, our problem is not really defining baselines because they've already been defined. Okay. Our problem is what to do with them. Okay. So here in these laws, basically we made a distinction between internal waters, which are under absolute sovereignty of the Philippines, full, complete, total, walang exceptions, and the territorial sea, which is the orange spot there, outside the baselines. Here you have only one concession in favor of the international community, and that is to allow foreign ships to pass through. Okay, that's the only concession that they have. If it were territorial waters, you would still assert territorial sovereignty in all other respects. And this is our assertion. This has been our position. This was our position at the time. Unfortunately, during the UNCLOS negotiations, this position was not accepted. Okay. And later on, I'll show you what the international community did eventually accept. So yeah, next. The next development, therefore, you fast forward to the 1970s when we made the Calayan Island Group claim. Okay? Well, don't call it a claim. Note to self, don't call it a claim again. When you asserted sovereignty over the Calayan Island Group. Okay? And that was through PD 1596, which drew this box to the left of, to the west of Palawan. Again, if you look at PD 1596, you assert full, complete, absolute sovereignty over it as if the entire thing were a piece of land. And did not describe anything or say anything about territorial seas, which is slightly different, hence the difference in the coloration. And, however, on the same day that this decree was issued, we also issued, next slide please, we also issued PD 1599, which established the exclusive economic zone, which now is another type of maritime zone, which is not absolute sovereignty. Here you only have sovereign rights over natural resources, living, non-living. And this is part of what was developing international law, what the international community was willing to accept as being the entitlement of a coastal state. we took advantage of that development and declared at the same time as we issued PD 1596, PD 1599, same day. Since PD 1599 is later in sequence, then it effectively amended PD 1596. And so you have that change in the box to KIG, at least as far as the waters are concerned. No, the exclusive economic zone here refers only to water. It does not refer to land territory. Okay? So, again, this is another source of confusion, which later we'll discuss. So that was it in 1979, and basically one provision of PD 1599 says that we're supposed to negotiate the boundaries of the exclusive economic zone whenever they overlap with other states. Thus far, we have not done so. However, if you take a look at the current state of international law, in cases where not two neighboring states have not yet defined the boundaries between them, the default position is basically the equidistant line. And so, next slide please. If you use the equidistant line, actually the full extent of the exclusive economic zone would probably be something like this. That depends on whether from where you measure the equidistant line. Okay, but it's probably something like this, if ever. Yes. The treaty barrier is still there. That's why the colors are also still there. And this is how you see. This is how you understand the basic difficulty, the basic problems that you're faced with when you only look at law and don't look at its effect. If you look at the map as the effect of the laws, you'll see the inconsistencies that arise. And that's why it's very graphic. This needed to be a very graphic explanation. Okay. So yeah, that question raises the possibility, the problem. Okay, what happens to those areas outside where you're supposed to be asserting more powers than the areas inside? Diba? If you look at the colors, it's inconsistent. So that is the basic problem that we have been faced with since 1979, which has not changed really, except for a slight adjustment. Next slide, please. Which did not really change until 2009, when the issue of RA 9522 came up, the new baselines law. Okay. And if you look at the actual effect of RA 9522, you will not see much of a difference. What's the difference? The real difference is this. Next slide, please. It actually just, oops, oh wait. Before we go into the actual, could you go forward a little bit? One more. Okay. The basic difference is this. RA 9522 merely amended the location, the coordinates of the baselines in RA 95446 in the previous one. It merely amended the previous drawing. Right? And you'll notice that in certain areas, the blue areas, it covered more waters. In certain areas, the red one, it reduced certain waters. Now, if you compute the total areas of these two, we gained more than we lost. Actually, it's just that the lines moved a bit. But everything else is the same. All the colors would still be the same. So could you go back one slide? Yeah. So it's still the same. With respect to Attorney Vergara's here, who works with Attorney Roque, that is the situation with respect to 9522. Did not really change anything. And it really did not affect much of the previous situation. In 2009, we also filed the claim to an extended continental shelf in the Benton-Price region. I was part of that effort. And basically what happened there was that because of certain provisions in international law, we were able to lay claim to that fleshy colored area there beyond the exclusive economic zone. We're claiming rights or jurisdiction to the resources in the seabed in that area. Okay, the seabed under the sea. Whether there's oil, probably not. But more likely minerals, genetic resources, whatever we find there, supposedly, we're claiming it in accordance with certain rules and international law. Okay? And this is still pending. Good news is that, we expected that this claim would not be on the agenda of the Commission on the Limits of the Continental Shelf. That's the international body that's supposed to check the validity of this claim. We did not expect it to be tackled until maybe 2013 or 2014. But we got word that it will be tackled in September this year. Okay? Which is good news for us. In the sense that it will be processed faster. Bad news in that it